Welcome back. And so we're still very much staying with issues that, have bearing on the heartbeat of the nation, from the, Benue killings to electoral reform. We're also reflecting on judicial reform amid concerns of lack of transparency and corruption in the judicial sector, most of which border on election cases being determined on technicalities. We have contradicting, court judgments from courts of coordinate jurisdiction. The NJC has moved in recent times, wielding the big stick, demanding in the first instance, that were last month, that the Imo State government should reverse the appointment of a judicial officer, and then, suspending 3 judicial officers for 1 year in the first instance, without, payment of the benefits. So what are the implications of these reforms, and how far do they go? And what are the other areas of reforms that are required in the judicial sector? We have joining us to have this conversation the Attorney General and Commissioner for Justice in Benue State, Mr. Ben Udo, Ebonyi State, I beg your pardon. We've been talking a lot about Benue. Mr. Ben Udo joins us on the program today. He's also the Chairman Attorneys General's, I believe, body in the country. Mr. Udo, thank you so much, sir, for joining us on the program.
It's my pleasure.
So let's start with the move by the NJC, I said earlier in the commentary, to suspend some judicial officers. In both, letter and spirit, how has this, impacted on the judiciary to sort of restore sanity for starters?
It's my pleasure once more, and I am glad to be with you this morning. The reform by the judiciary, it's something to commend. It's a law profession is a noble profession that is guided by rules. And the NJC regulates the conduct of the judges, while the legal practitioners disciplinary committee regulates the conduct of the private legal practitioners. So in the move that is currently ongoing and sanitizing the system, we commend the NJC, because if they don't do that, it will be tantamount to political interference and attempt to influence judicial outcome or delay in the implementation of judgment. So what they are doing by disciplining judges is commendable, and that serves as a check and balance. Otherwise, if they don't do so, so many of the judges in the country will abuse judicial processes that they are supposed to uphold. And this goes along with to tell you about the rule of law. The rule of law is the lifeblood of every functional democracy. So when it fails, governance collapses and trust erodes. So the Nigerian judiciary is not just a dispenser of justice. The Nigerian judiciary is a stabilizing institution in our constitutional democracy. If they fail to do so, if NJC failed to do so in disciplining the erring judges, and legal practitioner disciplinary committee failed also to do so in disciplining private legal practitioners, then definitely governance will collapse, trust will erode, and our functional democracy will fail.
All right. The reason why this is particularly important, Honorable Commissioner, is because, as you said, this is the fulcrum. If this collapses and then the entire thing has collapsed, they say the judiciary is the last hope of the common man. But let's talk about a few things. Let's begin with basic housekeeping within the judiciary. For those of us who are outside in, we look from outside into the judicial space. We appreciate some of the efforts so far by the NJC, as my colleague has alluded to, the reprimand and disciplinary action. But what do you think is going on with the issues of what we're seeing in the, I don't think it's new. I don't think whether it's the lawyers themselves that are causing the problem, or it's a lack of clarity from the bench, or it's just mischief from the politicians, where we will get a judgment from courts that is supposed to give some sense of finality or some level of closure, but it just opens up a box of confusion because everybody is looking at that judgment from different lenses, and all of these parties have lawyers helping to interpret, and they are all grandstanding. For instance, what is playing out in Osun State.
I didn't get your question clearly, sir.
So my question is, how come we get judgment from courts, and instead of it to bring closure, as I always ask, it brings more confusion? Is it a problem from bench, the bar, or mischief of the litigants, or misunderstanding of the litigants here?
Both problem from the bench and problem from the bar. And the reason why I said so is that sometimes the bench, maybe because of political interferences. For example, state high court and federal high court has concurrent jurisdiction on some matters. Now, you can see the state high court giving judgment, and someone running also to the same federal high court that have concurrent jurisdiction with the state high court, maybe to get same judgment or to quash decision of a court that has concurrent jurisdiction with the court of first instance. And these have created a lot of problems for the judiciary. Now, lawyers too, in a bid to justify money that are being paid to them, professional fees by their clients, so they're also helping in messing up the system. But with what the agency is doing currently, now, if you get such, there are things in place to punish judges who are found worthy of doing so. Now, if such goes in appeal, there is a punitive cost for lawyers who are promoting such, and we must also be intentional. We must be intentional in doing this, because if the judiciary, like I said, if we are not able as an arm of government, if we are not able to ensure due process and then accountability and access to justice, now the judiciary will definitely collapse. So most of all these things are primarily caused by lawyers too. Lawyers, because they want to justify the pace of the paid to them by their clients, their professional fee. They also want to do mischief and be able to get judgment at all costs. So these have really caused a very big problem. And I am so happy that NJC is doing a lot now in correcting these anomalies.
Let's talk about judicial precedents and the bearing that they have on determining subsequent cases. When we refer to, cases like Abegunde and the bearing that it has on defections, it appears as if judicial precedents, either it has to do with electoral cases or land cases, have not particularly resolved socio-political issues within the polity. Is there anything that you find wrong with our jurisprudence that need to be elevated, such that these judicial precedents can carry more weight?
Yeah, I want to commend the Attorney General of the Federation, Fagbemi SAN, and for what they move, that the things he set in place with the aim of correcting this. Now he has set up he has set up a committee that will look at our laws, review them, and then reform some of them. Currently, there are 54-member Presidential Law Reform Review Committee that will look into this. Now he is also codifying and recodifying our laws. And all the 36 attorneys general of the subnationals have keyed into it, so that as at the federal government, as they are codifying and recodifying this, amending and reforming this, now it will be stepped down at the subnational too. Because if we don't do this and then amend some of these our laws, it will become a bad precedent. And if we don't correct it right now that the move is ongoing, it's going to cause more problem for the judiciary. So currently, the Presidential Law Reform Committee, Review Committee have started work. And I'm sure at the end thereof, some of these obnoxious laws will be reformed. Some of them will be reviewed. There will be amendments. And then once we have all this, we'll get it right. So as it is going on currently at the federal level, the subnational have also keyed into it, and we are currently doing so that it will be a thing of the past.
So, Honorable Commissioner, let's go back to the issue of basic. I like to stay around the issues of housekeeping, and I'll use two instances. And the reason I'm asking this question is because I do not know whether the reprimand is sufficient enough. Maybe perhaps is why the perpetrators of this crime within the judicial sector, whether it's bar and bench, continue. So basic, if you show up in court, I think the basic thing to find out is whether that court has jurisdiction to hear that particular case. But we see that even some judges entertain those particular cases. They may not speak on or rule around the merit of the case. Maybe it does ancillary issue, but a ruling is a ruling, and you have to set it aside if you're not comfortable with it according to our law. So I use that as a first instance. We've also seen, even at higher levels of court, where justices have adjudicated over reliefs not sought and dragging into some of the flags that our judicial system has gotten in the last few years in that sense. So what level of reprimand do you think is necessary to begin to send literal shock waves like the economic policy of President Bola Tinubu did within the economy that is required within the judicial sector? I mean, something drastic, something earth-shaking, something that spells you can't do that here. One strike, you're out.
Thank you very much. Let me also commend the AGF too for the Administration of Criminal Justice Act protocols that and guidelines that he just approved. And at the subnational too, we also have the Administration of Criminal Justice Law of various states, the protocols. We have the protocols now and the minimum standard for this administration of the Criminal Justice Act and the Criminal Justice Law for the various states of the Federation. Now, under this, most states have reviewed the Administration of Criminal Justice laws. And with this protocol in place, now, lay prosecutors has been prohibited by these protocols. Lay prosecutors cannot prosecute. Now, stay of proceedings have also been abolished by these protocols. Now, so this will go a long way in helping us. For example, in Delta State, they have amended the Administration of Criminal Justice law that if you go to court as a lawyer and you don't have a good case and you want to use that, your inability to prepare yourself in order to defend the part case that you are involved in, and you keep asking for adjournment, if you do so first, second, the third one, there will be punitive cost against you. This is to curtail this. Now, for stay of proceeding, it has been prohibited. Now, so you cannot just come because a matter is not favoring you. You rush to another court to now get an order of the court and asking the court of first instance to stay proceeding pending the determination of that matter at the upstairs. So these are the reformation that the Administration of Criminal Justice Act and Administration of the Federation and Administration of Criminal Justice laws of various states have brought into play. And it's a very good reform. And you see, this reform have created a paradigm shift from the retributive justice system we had to the restorative justice system we ought to have. Because the justice system we had before now is a justice system that uses two approaches in crime disposal, punishment and vengeance. But the Administration of Criminal Justice Act of 2019 and that of the various states have intentionally moved from using punishment and vengeance as approaches for crime disposal to using reconciliation, restitution, restoration, and reintegration and it is
All right.
helping us, especially in court the conjunctions.
All right. As we continue to reflect on, reforms in the judiciary, I asked the first question deliberately, to see your position on these issues. And again, against the backdrop of even subsequent judicial decisions that have come through from the courts, it appears as if there are no guarantees that even the big stick wielded by the NJC can go so far. And another electioneering year is upon us in a couple of months down the line. So as a result, perhaps this is responsible for the position that some have expressed, that the NJC itself should be scrapped, that it is counterproductive to the ideals of a federal system, and that the idea of submitting disciplinary processes to an executive body is against the idea of a federation. What are your thoughts on this? And what other ways can the judiciary exercise discipline within its own sector?
Thank you very much. Post-election litigation in Nigeria have really tested the judiciary strength. And despite the pressure, most judgments have been consistent. I must be sincere with you. Most judgments have been consistent with legal precedent. So we must do everything possible to safeguard the judicial independence as national security imperative. So the judiciary should not just be vilified when it delivers unpopular judgments. This erodes the rule of law. But like I said, what the NJC, what they are doing in discipline, erring judges is commendable. And then for the legal practitioners too, in the legal practitioner disciplinary committee, they measure in place. The rules have been amended, and the rules of professional RPC, the rules of the RPC, the rules for professional conduct for legal practitioners 2020, it has been amended, and lawyers have it. They read it every blessed day. They know that when they go contrary to this rule, because Rule 55 provides that failures of all to uphold all the rules in the professional conduct will be tantamount to professional misconduct. So they know the implication once they appear before the legal practitioner disciplinary committee. For judges also, they also know the implications. So the laws, the rules in place, and the laws in place, the policies in place are enough to help in checking segmenting the excesses of lawyers and the judges. And I want to believe that with those in place, the bar and the bench must also on their own insist on integrity, insist on ethics and continuous improvement, and then we'll definitely get it right at the end of the whole matter. All right.
As we're going to wind down, democracy, sovereignty of states is also about optics, which is why America uses both their hard power, military, wealth, and soft power, using Hollywood and all of that. And one of the things, I like the way Leonard Silk, who is a member of the Inner Bar, Olisagbakoba, puts it. He calls it administration of justice and judicial administration. And of course, the administration of justice, there's a lot of things that has been done. There's room for improvement. But judicial administration is one of the hot buttons within the judiciary that a lot of people don't want to touch. As the CJN sitting on a lot of committees chairing all of this in terms of discipline. But where I'm going to with that foundation I laid, which I would like you to speak to, I started with the issue of optics, because when we see politically exposed persons, children, wives, or husband find their way into the judiciary the way we see and the proliferation we see in Nigeria, already we have a very horrible trust quotient for the system. And when you add that to that weak trust quotient, it complicates and makes it even convoluted. So I would like you to speak to the issue of how to manage it as to helping the public to have better confidence in the judicial system, because we see now governors' wives are becoming judges. We even had a senator one time who talked about his own wife helping his colleagues, and that became a source of controversy. He said that's not what he meant. We can go on and on. Their children, and even judges' children becoming judges. If this is not properly checked, whatever it is we're doing in terms of administration of justice, with a poor judicial administration, is going to be counterproductive. Do you think so, or do you agree with me?
Thank you very much, Mr. Geoffrey. You see, the laws providing for requirements for one occupying the position you have mentioned, being a member of the bench, is express. Irrespective, so if someone is qualified to occupy a particular position, especially in the bench, and the person meets the requirement of the law, I cannot be advocating that the person will be denied. If I assuming that my father is a judge and I am qualified after applying to be a judge, there is no law prohibiting me from being the judge. You cannot use because my father is a judge and then I applied and then it will also seem like a family business. No, we have laws. We have laws providing for these positions and the necessary requirement for these provisions. Now, but I said, what the NJC is doing and what the legal practitioner disciplinary committee, what they are doing is already serving as a check and balance to regulate the conduct of members of the inner bar, members of the outer bar, and the bench. And let me also say this, sir. All we need in this country is, especially in court administration, is to be able to overhaul our court administration. I tell you, we need in our court administration, we need a CEO to be in charge of our court administration, a seasoned administrator, not even a lawyer, because you discover that when we have a head of court who is a CJ, we now have the person who is in charge of court administration, who is the chief registrar of the court, and is a lawyer. If we're able to get a seasoned public administration to be CEOs of the court, I want to submit that we will definitely get it right. Now, the CEO in charge of the administration of all the court processes, while the head of the court, the chief judge, will be in charge of the court proceedings. So when lawyers are not good managers in terms of, they're not good administrators in terms of administration of criminal justice. So I want to advocate that the only way this can also help, the only way we can help in reforming the administration of justice system in Nigeria is to have a non-lawyer to be in charge, of be the CEO of a court, while a lawyer will hail the court. When we put these things in place, our federal government also must do everything possible to invest more in judicial infrastructures and automations. This will also help in regulating the processes and regulating the activities, the judicial process in the court. And I assure you that when we do this, Nigerians will now stand to defend the court. Sir? What did you say?
You can wrap up in 15 seconds.
I said Nigeria must defend the court as the arbiter of justice, and not only when it suits them. Sometimes when a matter does not suit you, that is when you see people protecting. When it suits you, people will not protect. So I want to encourage Nigerians that we must stand up to defend the court as the last hope of the common man. And I also want to say, on a final note, that the rule of law should not just be a mere slogan. It is the soul of democratic governance, and the judiciary is a custodian of that soul. So we must do everything possible to protect this. We either strengthen it or we lose the nation.
Indeed, and the issues are complex, but not beyond us. We must anchor at this point, and thank you very much, sir, Mr. Ben Udo, the Attorney General and Commissioner for Justice in Ebonyi State. Thank you for your time on the program.
Thank you so much for thanking me.
All right, from this point, we'll take a break now, and when we return, we'll turn down on the hard talk and bring you something very, very interesting. We're going to piggyback to the 90s and then come back to 2025, where our guest has launched a new music video. Stay with us for this conversation. We'll be right back.